You're sitting in a sleek conference room, and across the table is your banker or landlord. They slide a contract toward you and say, just sign here, it's standard. You glance down, everything looks fine, until those two words hit you, personal guarantee. One signature, and suddenly your home, your savings, your retirement, even your kids' college funds, they're all on the line. Most people sign personal guarantees without a second thought, but the ultra wealthy, they never sign them unprotected. And today, I'll show you why. I'm the business guy, the CEO of the Lawyers Limited law firm and asset protection planners, helping clients worldwide. And if you want to protect your assets like the wealthy do, hit that subscribe button if you haven't. I share strategies that most lawyers won't. So what is a personal guarantee and why is it so dangerous? A personal guarantee is a legal promise you make to be personally responsible for a business obligation or an obligation of someone else. This means that if your company fails to pay or the person you guarantee fails to pay, it sounds innocent at first. You're just backing up your business loan or the other person or lease with a signature. But here's what they don't tell you. If your business goes under or the person doesn't pay or simply misses a payment, you could lose your home, your personal bank accounts, your retirement funds if not properly protected, even your future wages through garnishment. And here's the kicker. You don't even have to do anything wrong. One bad quarter, one supplier lawsuit, one market crash, and suddenly a wrecking ball aimed directly at your personal life. Now here's a real case study, the signature that cost him $4.7 million. Let me tell you about Brian, a real estate developer in Nevada, mid-50s, successful, ran several LLCs. He signed a personal guarantee for a construction loan, $2.5 million, and when the 2008 crash hit, two of his projects went underwater. The bank foreclosed and sued him personally for the difference. Because of that one signature, he lost his primary residence, he had his wages garnished for years, he couldn't buy another house for over a decade. The LLC didn't protect him because the bank had the magic bullet, his personal guarantee. So here's why business owners keep making this mistake. So why do smart people like Brian sign these? 3 reasons. First, they think it's just paperwork. They trust the lender or landlord, and they don't realize there's a legal way to shield themselves. Most business owners are taught to say yes to the deal and worry about risk later. But the wealthy, they do it the other way around. They structure first, sign second. And that's what we're talking about today. So how the wealthy shield themselves from personal guarantees. Now let's break it down. Step 1, use a proper LLC structure. Yes, the LLC is your first line of defense, but alone, it's not enough. In fact, creditors pierce that veil all the time, especially when personal guarantees are involved. So that's why the smart money layers their LLCs, and here's how they do it. Step 2, add a Cook Islands trust with a Cook Islands LLC inside of it. And this is where the real protection begins. So at my law firm, Lawyers Limited PLLC, and through our assetprotectionplanners.com platform, we've set up more Cook Islands trusts than anyone in the world. I've been doing this for 34 years and forming Cook Islands trusts for nearly 30 of those. And here's the secret structure that we use for clients at risk of personal guarantees. First of all, we start with a Cook Islands Asset Protection Trust. Inside of it, we nest a Cook Islands LLC, and it'll be a Belize Trust and LLC if you're already in a lawsuit, since the Cook Islands isn't fond of people currently in litigation. Now, we typically pair this with a Swiss bank and stock brokerage account. You as the client are the manager of that LLC while the waters are calm. And if a lawsuit claim hits, our licensed bonded trustee company law firm can step in to protect your assets. And here's what that means. Even if a judge in the U.S. says turn over your assets, you're legally powerless to comply. And since the Cook Islands doesn't recognize U.S. court orders, that lawsuit hits a concrete wall. But what if you've already signed a personal guarantee? So here's where it gets interesting. Let's say that you already signed one or several and now you're sweating. You can't go back and erase the signature, but you can protect what you got now from being taken in the future. We use a technique called equity stripping, where we place friendly liens against your assets, especially your real estate, in favor of your offshore LLC. So if a creditor comes knocking, there's nothing left on paper for them to grab. And if needed, we get a third-party lender to purchase those liens and put the proceeds in your offshore trust. So we've done this for business owners in litigation, real estate developers with seven-figure exposure, high net worth clients who thought they were safe with an LLC, and it works. Now keep in mind, the clock is ticking, the statute of limitations and timing. Now here's your cliffhanger moment. Let's say you move your assets offshore after a lawsuit is filed. Does that work? Well, maybe, but here's the catch. In the U.S., the fraudulent transfer statute of limitations varies by state. In fact, in some cases, just 2 years. But offshore, like in the Cook Islands, it's much tougher for a creditor to win, especially once the trust is seasoned. So the earlier that you act, the stronger your defense. Want to know the worst time to move your money? After the courts have already frozen it. That's why we always say you don't buy fire insurance when your house is already in flames. Okay, so here's why lenders want your personal guarantee and how to push back. So let's zoom out for a second. Why do lenders insist on personal guarantees? Because they know your LLC isn't enough. They want access to your personal bank accounts, assets, and future income. In short, they want to own you, not just your business. But here's the subtle move we teach our clients. Rather than outright refusing the personal guarantee, they negotiate terms with structure in place. For example, they might create a limited personal guarantee capped at a specific dollar amount, or a burn-off guarantee that goes away after 12 months of on-time payments. Or they sign the guarantees, but their assets are already secured offshore, and that's the key. And that's the art of the deal, fortified by law. But keep in mind, most major banks will dig in their heels. If you want our money, you have to do it our way, they say. So that's why the asset protection strategy we just outlined is your refuge. Okay, so here's some stats that'll make you think twice. So you still think personal guarantees are no big deal? Consider these. 65% of business owners with loans over $250,000 have signed a personal guarantee. Over 52% of business bankruptcies result in personal financial losses for the owners due to guarantees. The average lawsuit in commercial contract disputes is $91,000 to $1.3 million. So what do the wealthy do? They treat personal guarantees like radioactive material, something that you only handle with thick gloves and extreme caution. So never touch them directly if you can avoid it. And signing as a guarantee for your child or family member, and I get it, you love them, but don't do it. You can't save someone else from drowning if you're going under too. Protect yourself first, then you're strong enough to help others. Let's talk about the invisible fortresses of the wealthy. You know what's wild? Most ultra-wealthy clients that I work with don't actually own what you think they do. They control properties held in land trusts, businesses wrapped in layers of LLCs, assets secured by offshore structures, liens that make their real estate look broke on paper. These aren't loopholes. These are legal structures used for decades to keep assets safe from lawsuits, judgments, and yes, personal guarantees. And that's the difference between someone who survives a lawsuit and someone who loses their life savings because of one signature. Okay, so what should you do right now? And if you've already signed a personal guarantee, don't panic. Act. And even if you haven't signed one yet, don't wait until it's too late to protect yourself. Here's what I recommend. First of all, visit assetprotectionplanners.com. You get a whole lot of free information there. If you're serious and not curious, you have over $500,000 to protect, schedule a free consultation with my team. let us build a custom legal shield around your assets. And remember, I'm the CEO of the Lawyers Limited Law Firm, a licensed law firm. This isn't theory. This is what we do. We've helped, I believe, over 143,000 clients, many just like you, create invisible legal fortresses that protect them from financial ruin. So if you're getting value from this video, go ahead and hit subscribe if you haven't. We release videos every week on protecting your wealth legally and effectively. And I'm not here to scare you. I'm here to educate you so that you can move forward with confidence. Final thought, one signature can change everything. So let me leave you with this. You've worked too hard, built too much to let one sentence in a contract destroy it all. A personal guarantee is not just ink on paper. It's a loaded weapon pointed at your financial future. So if you've ever signed one, or if you're about to, ask yourself this, what's protecting you? Because if the answer is nothing, let's fix that before it's too late.